Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's video. On today's video, we're continuing with our prior discussion, which had to do with the Division of Workers' Compensation and their recent discipline of over 400 qualified medical evaluators. So this is part 2 of this current discussion. And we began this discussion with the rhetoric question as to how will you bill your very next QME report? Now that we know that the Division of Workers' Compensation has a new interpretation of the complexity factors, and even though we know that that interpretation of the complexity factors is suffocating, is restrictive, and dramatically reduces the value of your QME report by as much as 60%. Now that you know all those things, how will you bill your next QME report? And we spent about 30 minutes in our last discussion talking about some new insights into the causation complexity factor and some new insights into the report preparation time, which is called into dispute now under the DWC's new interpretation of the ML 104. And it seems that several authoritative bodies, including CSIMS, the California Society of Industrial Medicine and Surgery, and also one of the former authors of the CCR 9795 regulation, both of these authoritative bodies have come forward to oppose the DWC and the DWC's interpretation of the complexity factors. Well, it remains to be seen how this is going to be resolved, but the Division of Workers' Compensation is going to be called into court this week. As this video is being recorded, this week the DWC is scheduled for a hearing in Los Angeles County because several QME doctors who had their license non-renewed, had their QME credential non-renewed, have filed suit against the Division of Workers' Compensation. Well, since that suit was filed, much support has come from the medical legal community in support of the doctors and in opposition to the DWC's interpretation of the complexity factors. Now, we may never really understand fully the motives of the Division of Workers' Compensation for imposing their will and creating this so-called new interpretation of the complexity factors. But the end result of this maneuver by the Division of Workers' Compensation has been extremely devastating. As I said, more than 400 doctors have been put through living hell by the Division of Workers' Compensation. They've had their QME renewal upheld. Many have been ordered to pay restitution in the terms of thousands and thousands and thousands of dollars. Doctors have been placed on probation for a one-year time period, and the effect and the impact has been devastating. Well, the DWC is going to be called upon to answer for their actions this week. So in the meantime, until a resolution on this standoff is reached, the question becomes, how will you bill? Well, California Society for Industrial Medicine and Surgery has suggested that you go ahead and not be intimidated by the DWC and go ahead and bill your report preparation time in those instances when you qualify for a bona fide ML 104. It's the opinion of CSIMS, and it's also my opinion, that this restriction on report billing time is going to wash away, because tracing this misunderstanding back, the misunderstanding traces back to a simple typographic error wherein the transcriptionist who put together the language of CCR 9795 omitted to hit the return button on her computer keyboard twice to separate out some paragraphs that formally and historically have always been separate. It's a simple typographic error that simply involves the omission of hitting the return button on the keyboard twice. For that, over 400 doctors have been disciplined. It's my opinion that this is going to disappear. So CSIMS feels that we should not be intimidated, and that in the presence of a bona fide ML 104, our report preparation time will be paid and will not fall under scrutiny. And in addition to the report preparation time controversy, we spent some time talking about causation as a complexity factor, and we contrasted real-life events with the Division of Workers' Compensation's narrow, tight-fisted interpretation of complexity as of causation as a complexity factor. Now, it's the position of the Division of Workers' Compensation that causation as a complexity factor can only apply, can only apply in situations that involve a denied claim. So, what does that mean? That tells us that the Division of Workers' Compensation considers causation to involve only a determination of AOE and COE. And is that the only circumstance wherein causation is an issue? Is causation only an issue when there's a dispute over AOE, COE? Well, it's my opinion, and these other authoritative sources have come forward to support my opinion, so we're all on the same page. It's my opinion that causation is an ever-evolving, ever-developing, morphing, changing, transitioning, and dynamic aspect of each and every case that we evaluate. So it's my opinion that causation as a complexity factor applies not only at the inception of the claim, which is the position of the Division of Workers' Compensation, but also throughout the lifetime of a claim. Now, in opposition to the DWC, both CSIMS and the author of CCR 9795, whose name is Sue Honor Bangarov, have both opposed the Division of Workers' Compensation's position on causation as it relates to a denied claim. And in our last session, I shared with you what both of those parties stated. So let me just share with you here, and that will give us an introduction for today's discussion. Okay, this is from the attorneys in Los Angeles County who are representing denied qualified medical evaluators. This lawsuit is set to be heard this week. So in their lawsuit, they talk about causation as a complexity factor. They state that the DWC's new and different criteria for the application of the medical causation complexity billing are contrary to reality. And what they mean by that is that in reality, causation is an issue throughout the lifetime of a claim. And they give an example, and it's important for us to review this example. They say, for example, it's well established that an employer may accept an injury as industrially caused because the employee complains of back and leg pain after lifting something heavy. But when the QME interviews the injured worker and takes a full medical history, the QME may determine that the injured worker actually injured himself a week earlier sliding into home plate during a recreational softball game unrelated to work. The QME may then decide that the back and leg injuries are more consistent with the non-industrial sliding injury than with the industrial lifting injury. Medical causation on an industrial basis may then be refuted, even after the claim has been accepted. Industrial causation can then be refuted. So they say that the DWC's changes to the written text of the causation complexity factor fails a reality check against real-world facts and circumstances. Well, that's the position of the lawyers in Los Angeles. The position of the author of CCR 9795 herself, Ms. Honor Bangarov, says something very similar. And we won't go into it because it's basically duplicative as to the position of the attorneys representing the QMEs. So let me ask you, is that scenario that's described in the lawsuit and echoed by Miss Honor Van Groff, is that a real world scenario? Does that possibly happen? Is it possible that we could have an accepted claim and then based upon our complete interview and physical examination of the examinee, come up with an opinion against industrial causation, which then could refute the claim? Is that just a made-up example, or is that something that we could actually experience? Well, just yesterday, not making this up, just yesterday, I heard my fax machine going off, and over the fax machine came a new cover letter which details this exact scenario. And I'm going to share that with you in just a couple minutes. So the point of today's discussion, and it's going to be brief, the point of today's discussion is directed primarily at the Division of Workers' Compensation, but also towards you as qualified medical evaluators, and that is, we all must realize that causation applies as a complexity factor throughout the lifetime of a claim, because causation is an ever-evolving, ever-developing issue that will be important to discuss at all points during the lifetime of a claim. And we shared an example yesterday about an examinee from my own files who I just recently reevaluated. By that I mean within the past 10 days I recently reevaluated her for the 4th time. And I demonstrated to you how the first time that I saw the examinee, more than 18 months had passed since the date of injury. It was already an accepted claim, yet I still went into a lengthy discussion about causation because I had a written request from the parties. The report qualified as an ML-104. I billed causation as a complexity factor. I billed for report preparation time. The report was paid 100% with no objection and no reduction. More than 15 months later, I reevaluated the examinee, and this time the parties requested a much more detailed discussion of causation. Now, according to the Division of Workers' Compensation, at this late point in the life of the claim, causation is no longer an issue because the claim has been accepted. So the DWC limits their scope of causation to AOECOE only. But AOECOE is not the only issue involved with causation. And so the parties asked for a very detailed, specific request. In fact, it was more like a demand for a discussion of causation. This is now almost 30 months after the date of injury. Well, I prepared a report. I used causation as a complexity factor. I billed for report preparation time under ML-104. The report was paid 100% with no objection and no reduction. Another year passed, and they asked me to reevaluate the examinee. In the time between the second reevaluation and the third reevaluation, several things had happened. The examinee became represented by an attorney, by an applicant attorney, and we now had another party involved in the case. There were new allegations of 2 periods of cumulative trauma, one period preceding the specific incident of injury and another period following the specific incident of injury. There was a new issue related to body parts involved, and the examinee claimed involvement of the lower back as an involved body part, which prior was related, the injury was related to cervical spine and left upper extremity only. And in addition to that, the examinee disclosed a recent motor vehicle accident, which also involved injury to the cervical spine and the lumbar spine. And the examinee also disclosed that she was now working for a different employer, different from the employer involved at the time of the injury. New issues, new complex issues of medical causation developed during the life of the claim. Now, is this a unique scenario? Is this a rare scenario? Is this the exceptional scenario? No. No, it's not. This is ubiquitous. This is what happens with each and every claim that we evaluate. Causation is an ever-evolving and ever-developing issue throughout the lifetime of the claim. So for the third evaluation, more than almost 3 years after the date of injury, after the claim had been accepted, after benefits have been delivered, after medical care is being delivered and is ongoing, the parties requested a new discussion of causation. Now, according to the Division of Workers' Compensation, at this late point, causation does not qualify as a complexity factor. Does that make sense? Does that make sense that simply because the claim is accepted and we have now new issues with additional body part, additional motor vehicle accident, 2 periods of claimed cumulative trauma, and a new subsequent employer, according to the Division of Workers' Compensation, this complex analysis of causation does not qualify as a complexity factor. Does that make any sense? It's the opinion of the Division of Workers' Compensation that causation can never apply as a complexity factor once the claim has been accepted, which is absolutely ridiculous. Makes no sense at all, and consistent with the description of the lawyers in Los Angeles and consistent with the description of Miss Honor Vangerov, the DWC's interpretation does not stack up against real-world reality checks. Well, it's amazing. With this case, there's an additional piece to the pie. So when I recently reevaluated her for all these new issues such as cumulative trauma, additional body part, a subsequent employer, all that stuff, I declared her permanent and stationary conditionally. I provided a conditional permanent and stationary declaration. The permanent and stationary declaration was conditional on her having a one-time follow-up visit with a neurosurgeon to determine if she was a surgical candidate or not. Pending that evaluation, I planned on providing the parties with my opinions and conclusions, all ratings, all apportionment determinations, etc. Well, they sent the examinee for the one-time evaluation, and after that one-time evaluation, they requested a 4th reevaluation, which is just simply several months after the most recent reevaluation. And I saw this examinee like last week or 10 days ago. Can you believe that in the time between when I most recently saw her 3 to 4 months ago and now, even more issues with industrial causation have arisen, and even now the parties are requesting even more detail regarding industrial causation. Now, for this most recent reevaluation, I won't be using causation as a complexity factor because this reevaluation is going to be billed as an ML101, because I saw her within 9 months of the prior evaluation. So I won't be using complexity factors. I'll simply be billing the straight hourly rate of $250 per hour. But the point is, even now, after all this time and all these evaluations, they're requesting even more detail on causation. Let me read it to you. We refer you to your previously communicated evaluations and reports and ask you to address your continued opinions that would be consistent with those previously expressed and was confirmed in your deposition testimony. In specific, you will recall your opinion of no impairment for the left shoulder, your opinion on what extent a cumulative trauma injury has been sustained, whether cumulative trauma has been sustained by the applicant up to the current date currently alleged, and identifying all causative factors to the various body parts alleged for any disability opined, providing us with your medical opinions. They say, Are the medical findings consistent with the original incident or injuries as reported? Did the applicant sustain an industrial injury? Was it a specific injury or continuous trauma? If the injury was due to continuous trauma, during what period did the injury occur? Are the subjective complaints supported by objective findings? And on and on and on it goes, with specific requests for an addressment of causation. So this case perfectly illustrates the point that causation is not just an issue at the inception of the claim with regards to AOECOE. Causation is an issue along the lifetime of the claim, because as we know, applicants and claims develop a barrage of issues related to causation that simply become unearthed, that become discovered throughout the life of the claim. Well, I no sooner finished our last video taping with you than I heard my fax machine going off, and a new cover letter came over the fax machine. Now, this relates to an examinee who I saw one time approximately 5 to 6 months ago. At the time, the date of injury was more than 1 year before my evaluation with the examinee. At that time, the claim had been accepted, the examinee had received medical treatment and was receiving ongoing medical treatment. There was no periods of temporary total disability. The examinee continued to work, but benefits were ongoing, so the claim was accepted. Well, in their cover letter, the parties requested a discussion of causation, even though the claim had already been accepted. This is going to exactly mirror the statements of the lawyers from Los Angeles and the statements of Sue Honor Bangarov. The cover letter says it's important that you carefully read this cover letter prior, they underline the word prior, to the examination, and that you respond to all of the questions posed in later sections of this cover letter. Does that sound like a specific request? Does that sound like a written request? That sounds very specific, doesn't it? Well, do they ask for questions related to causation? Let's find out. They say, and there's a whole section here regarding causation, it says. Regarding causation, it says. And there's a whole list of questions here regarding causation. It says your report should include your objective opinion regarding industrial causation. Specific issues to be addressed in the comprehensive medical report. Did the applicant sustain an industrial-related injury, either as a result of a specific injury, continuous trauma, or both? Please thoroughly address the following in your report. And there it goes on with questions and questions and questions and questions down to right here. All of this is questions related to causation in a claim that had already been accepted. So I provided a detailed assessment of causation. I used causation as a complexity factor. I billed for an ML 104, including report preparation time. The report was paid 100%. Now, what's interesting is, in my report, I opined against industrial causation, just like what the attorneys described in their lawsuit, that after the QME, which was me, obtains a thorough history from the examinee, I opined that there was no basis for an industrial injury. Industrial causation could then be refuted. Well, amazing. Amazing. In comes a cover letter yesterday. It says, On page 27 of your last report, you found that within reasonable medical probability, Mrs. Jones did not suffer an industrial injury on such and such a date. Your opinion is partially based on the fact that the applicant did not report her industrial injury or seek medical care until 6 days after the alleged injury occurred. Subsequent to receipt of your report, defendants denied the applicant's claim and discontinued providing the benefits. Is that exactly the scenario that's described in the lawsuit? Is that the exact scenario that Miss Honor Van Geroff cites in her declaration in support of disciplined doctors, disciplined QMEs? It's the exact scenario, and this is not unique. And this is directed towards the Division of Workers' Compensation. Do you hear me? Do you hear me? Medical causation is an ongoing issue that continually evolves and develops throughout the lifetime of a claim. Medical causation is not simply limited to a determination for or against industrial injury, meaning AOECOE. Industrial causation, medical causation, has many faces, has many forms, has many factors, is multifactorial and is multifaceted, and continues to evolve throughout the lifetime of a claim, as both of these examples, which are at the top of my desk. I did not have to search through archives of files to come up with these examples to share with you. These are everyday files. Every QME has these exact files on their desk. To say that medical causation applies as a complexity factor only in cases of a denied claim fails a real-world reality check and casts suspicion on the DWC's motives for imposing such a tight-fisted restriction on the causation complexity factor. So that leads us to the question and the conclusion of today's discussion. How will you bill your next report? The Division of Workers' Compensation has set up strict rules for our billing, and yet there are authoritative sources who advise us to not be intimidated, to go ahead and bill our reports as we always have. So where does that leave you? Well, my suggestion to you is this, and you can take this suggestion or leave it. It has no basis other than what appears to be the evolution of this controversy, and that is that the Division of Workers' Compensation has recently disciplined doctors who basically deserved it. Their reports were the worst of the worst reports in our entire industry, and I've reviewed several of these reports, and they deserved to be disciplined. It's my opinion that the Division of Workers' Compensation has no interest in disciplining doctors who properly apply the medical legal fee schedule. So in cases where a bona fide issue of causation exists, in cases where you receive a written request from the parties for an addressment of causation, you may consider go ahead and doing a fabulous job on the causation section of the report and invoking causation as a complexity factor. Similarly, if you have a bona fide ML 104 report, CSIMS is advising us to not be intimidated by the DWC, to go ahead and bill for our report preparation time, and it's my opinion that that is sound advice as well. Now, it's important that every single minute that you bill for be properly documented, that you don't use formulas, that you don't use estimates in preparing your time. I was talking with one doctor yesterday, and he told me that with regards to his review of records time that he bills for, he uses an estimate method wherein he estimates that it takes approximately 1 hour to review 1 inch of medical records. So if he receives 2 inches of medical records, he bills 2 hours. If he receives 3 inches of medical records, he bills 3 hours. 4 inches, 4 hours, etc., along a formula basis. It's my recommendation that you itemize your minutes exactly and that you bill exactly for what's actual, not for what's estimated, not for what's formulaic, but for what's actual. We're in the business of billing for what's actual. Not 1 minute overstated, not 1 minute fabricated, but only for what's actually really involved with the evaluation. It's my opinion that the Division of Workers' Compensation is simply looking for an improvement in our reports. And if you provide perfect, flawless, fabulous reports that are perfectly and properly and not fraudulently billed, you will probably be okay. But of course, that remains to be seen. So at this point, we cross our fingers for a favorable outcome in this week's hearing down in Los Angeles County. So this is Dr. Carpenter, and as a final note, I want to tell you that only you can decide how to bill your reports. I've reviewed many reports of doctors of all specialties, and let me tell you that very few of them dot every I and cross every T. Many of them can be picked apart and found to be fraudulent in their billing. My suggestion to you is to make sure that your billing is exact, it's perfect, it's proper, that you have perfect and exact justification for every single complexity factor and every minute that you're billing, and I don't think any party in the entire industry can complain about that. So this is Dr. Perry Carpenter. I hope this discussion helps you. I want to thank you for taking the time to join me on today's discussion, and I look forward to being with you on future discussions as well. And for now, I'm wishing you best of success in your career as a qualified medical evaluator.